The Factories Act 1948, Act No. 63 of 1948, Chapter 8, Annual Leave with Wages, 78. Application of Chapter 1. The provisions of this chapter shall not operate to the prejudice of any right to which a worker may be entitled under any other law or under the terms of any award, agreement, including settlement or contract of service, provided that if such award, agreement, including settlement, or contract of service provides for a longer annual leave with wages than provided in this chapter, the quantum of leave, which the worker shall be entitled to, shall be in accordance with such award, agreement or contract of service, but in relation to matters not provided for in such award, agreement or contract of service or matters which are provided for less favorably therein, the provisions of sections 79 to 82, so far as may be, shall apply. 2. The provisions of this chapter shall not apply to workers for in any factory of any railway administered by the government, who are governed by leave rules approved by the central government. 79. Annual leave with wages. 1. Every worker who has worked for a period of 240 days or more in a factory during a calendar year shall be allowed during the subsequent calendar year leave with wages for a number of days calculated at the rate of if an adult, 1 day for every 20 days of work performed by him during the previous calendar year. If a child, 1 day for every 15 days of work performed by him during the previous calendar year. Explanation 1. For the purpose of this subsection, A. Any days of layoff, by agreement or contract or as permissible under the standing orders. B. In the case of a female worker, maternity leave for any number of days not exceeding 12 weeks. And C. The leave earned in the year prior to that in which the leave is enjoyed, shall be deemed to be days on which the worker has worked in a factory for the purpose of computation of the period of 240 days or more, but he shall not earn leave for these days. Explanation 2. The leave admissible under this subsection shall be exclusive of all holidays whether occurring during or at either end of the period of leave. 2. A worker whose service commences otherwise than on the first day of January shall be entitled to leave with wages at the rate laid down in Clause I, or, as the case may be, Clause E, of subsection 1, if he has worked for 2/3 of the total number of days in the remainder of the calendar year. 3. If a worker is discharged or dismissed from service or quits his employment or is superannuated or dies while in service during the course of the calendar year, he or his heir or nominee, as the case may be, shall be entitled to wages in lieu of the quantum of leave to which he was entitled immediately before his discharge, dismissal, quitting of employment, superannuation or death calculated at the rates specified in subsection 1, even if he had not worked for the entire period specified in subsection 1 or subsection 2, making him eligible to avail of such leave, and such payment shall be made. Where the worker is discharged or dismissed or quits employment, before the expiry of the second working day from the date of such discharge, dismissal or quitting, and where the worker is superannuated or dies while in service, before the expiry of 2 months from the date of such superannuation or death. 4. In calculating leave under this section, fraction of leave of half a day or more shall be treated as 1 full day's leave, and fraction of less than half a day shall be omitted. 5. If a worker does not in any one calendar year take the whole of the leave allowed to him under subsection 1 or subsection 2, as the case may be, any leave not taken by him shall be added to the leave to be allowed to him in the succeeding calendar year, provided that the total number of days of leave that may be carried forward to a succeeding year shall not exceed 30 in the case of an adult or 40 in the case of a child. Provided further that a worker, who has applied for leave with wages but has not been given such leave in accordance with any scheme laid down in subsections 8 and 9, or in contravention of subsection 10 shall be entitled to carry forward the leave refused without any limit. 6. A worker may at any time apply in writing to the manager of a factory not less than 15 days before the date on which he wishes his leave to begin, to take all the leave or any portion thereof allowable to him during the calendar year, provided that the application shall be made not less than 30 days before the date on which the worker wishes his leave to begin, if he is employed in a public utility service as defined in Clause E of Section 2 of the Industrial Disputes Act. 1947, 14 of 1947, provided further that the number of times in which leave may be taken during any year shall not exceed 3. 7. If the worker wants to avail himself of the leave with wages due to him to cover a period of illness, he shall be granted such leave even if the application for leave is not made within the time specified in subsection 6. And in such a case wages as admissible under section 81 shall be paid not later than 15 days, or in the case of a public utility service not later than 30 days from the date of the application for leave. 8. For the purpose of ensuring the continuity of work, the occupier or manager of the factory, in agreement with the Works Committee of the factory constituted under Section 3 of the Industrial Disputes Act 1947, 14 of 1947, or a similar committee constituted under any other act, or if there is no such Works Committee or a similar committee in the factory, in agreement with the representatives of the workers therein chosen in the prescribed manner, may lodge with the Chief Inspector a scheme in writing whereby the grant of leave allowable under this section may be regulated. 9. A scheme lodged under subsection 8 shall be displayed at some conspicuous and convenient places in the factory and shall be in force for a period of 12 months from the date on which it comes into force, and may thereafter be renewed with or without modification for a further period of 12 months at a time, by the manager in agreement with the Works Committee or a similar committee, or as the case may be, in agreement with the representatives of the workers as specified in subsection 8, and a notice of renewal shall be sent to the Chief Inspector before it is renewed. 10. An application for leave which does not contravene the provisions of subsection 6 shall not be refused, unless refusal is in accordance with the scheme for the time being in operation under subsections 8 and 9. 11. If the employment of a worker who is entitled to leave under subsection 1 or subsection 2, as the case may be, is terminated by the occupier before he has taken the entire leave to which he is entitled, or if having applied for and having not been granted such leave, the worker quits his employment before he has taken the leave, the occupier of the factory shall pay him the amount payable under section 80 in respect of the leave not taken, and such payment shall be made, where the employment of the worker is terminated by the occupier, before the expiry of the second working day after such termination, and where a worker who quits his employment on or before the next pay day. 12. The unavailed leave of a worker shall not be taken into consideration in computing the period of any notice required to be given before discharge or dismissal.